If you're involved in a California probate, you may have heard that some executors or administrators are required to set up a probate insurance bond. Hello, I'm Paul Groh, Director of the Estate Administration Department at the Law Offices of Daniel Hunt. In this video, I'll explain what a probate bond is, when it's required, and how much it costs. A probate bond, also known as a fiduciary bond, is a type of surety bond held by the personal representative for the estate to insure them as they perform all their fiduciary duties as required in the California Probate Code. A probate bond protects the estate's beneficiaries and/or the heirs from any mistakes, intentional or unintentional, the personal representative of the estate might make in their role. Unfortunately, some executors or administrators fail to observe their fiduciary duties, which results in monetary damages for the heirs or beneficiaries. If the estate beneficiaries receive a judgment against the personal representative, the beneficiaries can then make a claim against the bond for compensation. If the claim is valid, the surety bond company that issued the bond will initially provide financial compensation to the beneficiaries. However, the personal representative will then be responsible for reimbursing the bond company for any payments they had to make. Here are some common reasons why a bond might be required. First, the decedent's will is being contested by family members or another party. Second, the executor or administrator is not a family member of the decedent. Third, the original executor named in the will has died or declined to serve, causing another person to be appointed in this role. Fourth, the estate has a high value. The larger the estate, the higher the risk to the beneficiaries if the executor mismanages the administration. Fifth, the will requires them to do so. Some wills have language requiring the executor to obtain a bond. Other wills waive the bond, especially if the testator trusts their executor implicitly or if the executor is also the sole estate beneficiary. And sixth, the executor lives outside the state of California. The court does not require a bond in every probate. A judge may waive the bond requirement if 1. They perceive a low risk of executor or administrator misconduct. 2. There's a provision in the will that waives the bond requirement. And 3. All the heirs are adults and all have consented to waiving the bond requirement. If the judge requires the executor or administrator to take out a bond, they must do so before the court will issue a necessary document called order and letters. The letters prove the personal representative's authority to collect assets from the financial institutions, sell real property, and generally act on behalf of the estate. Many factors pertaining to the executor or administrator affect the cost of obtaining a probate bond, including their credit score, relationship to the deceased, their occupation, their personal assets, and a previous bond claim history, or if they have a criminal record. Sometimes the experience level of the person acting can also affect the bond. The higher the risk level of the insured person, the higher the cost of the bond. The cost of the bond is also influenced by the size of the estate. Fortunately, the insured is only required to pay a percentage of the total value of the estate in order to be bonded, not the full amount. In Sacramento, a typical range for a bond per year is between $1,000 and $3,000. If you have any questions about securing a probate bond, please contact our office. We hope this video has been helpful, and if you have any questions about estate administration, feel free to contact the law offices of Daniel Hunt using the information listed below. Thanks.